Hi, folks. We're just going to give it a few seconds for people to be admitted, and then we will get started right on time here today. All right, well, welcome. I want to thank everybody today for attending this webinar with Wellnecity, Mental Health Parity, What Employers Need to Know. My name is Kate Sullivan-Morgan. I'm thrilled to be here today. I'm a partner in the healthcare group at Dentons, which is a large global law firm with a number of nationally ranked practices, including healthcare and employee benefits. I'm based in Texas, in Austin, and my expertise is in payer provider issues and digital health. But fortunately, for today's conversation, I'm joined by my partners, Marty Moderson and Kathy Babich from our Kansas City office, both of whom were recently named Best Lawyers in America again for 2025, right in this practice area. Marty and Kathy have represented clients together for 30 years, giving them extensive experience working on compliance issues related to self-funded medical plans, and really enabling them to take a practical approach, which is what I think you'll see and witness today. They're both partners in the Dentons Employee Benefits and Executive Compensation Practice Group, which Marty chairs. And our host and final panelist today is John Quinn, the founder and CEO of Wellnecity. John is a published author, a former McKinsey consultant, and has over 25 years of experience advising Fortune 1000 companies and startups in this space. He founded Wellnecity to help employers cut costs and improve outcomes. Wellnecity you'll hear more about, and many of you are familiar with, but it is the first of its kind consumer data platform that gives brokers and HR benefits leaders direct access to their own data, which we all know is not necessarily the norm today, allowing real-time, meaningful management of the plan. So in terms of the agenda for today, it's going to be a real discussion. We'd love for you to submit questions as you go through the Q&A feature. We'll do our best to get to those either live during the presentation or follow up afterwards if that's appropriate. And just to note that although we do have attorneys presenting some of the content, this isn't legal advice. It's really meant to be educational and give you some practical advice to understand where we are today with mental health parity. So with that, I will stop sharing those slides and we'll move right into the discussion. So why are we having this discussion today? Why is this important now? I think we're all very keenly aware of the context, the greater macro context swirling around with increased scrutiny on employer obligations and fiduciary duties. But more specifically and more acutely for today, we've been waiting for years for the final regulations to be passed for mental health parity, and that finally happened at the end of last year with them being effective this year. There's a lot of uncertainty in general in the healthcare industry right now. These regulations are brand new, so we don't have years of enforcement to look at to guide us. We have a change in the federal administration, and we have some pending challenges to these regulations. But that uncertainty only makes it more important to act and make a plan for compliance. The regulations have more immediate and specific requirements, as well as penalties and risks, which of course we want to avoid. So let's just start. Kathy, Marty, can you take us through the history here of mental health parity? Where have we been before these new regulations were passed?
Thanks, Kate. It's great to be here today to talk to everybody about this important topic. So the concept of mental health parity is not new, but as it has developed over the years, it has become more complicated and more burdensome for employers. So the first Mental Health Parity Act we had was in 1996. It was very basic. It required only that annual and lifetime dollar limits applicable to mental health could be no lower than similar limitations applicable to medical and surgical benefits. Then in 2008, we got the Paul Wellstone and Pete Dominici Mental Health Parity and Addiction Equity Act, or the MHPAEA, if you like bad acronyms. That act did basically two things. One, it significantly added substance use disorder benefits to the concept of mental health parity. So when we talk about mental health today, just know that that also includes substance use disorder benefits. The second thing it did was it added requirements related to financial requirements and treatment limitations. Those are two terms in the law. So financial requirements include lifetime and annual dollar limits, deductibles, co-pays, co-insurance, out-of-pocket maximums. Treatment limitations include the number of visits, days of coverage, waiting periods, those types of plan provisions. So essentially what the 2008 Act did was it said that financial requirements and treatment limitations imposed on mental health benefits couldn't be more restrictive than those imposed on medical and surgical benefits in a particular classification. And they created 6 different classifications for this purpose, which I will try to say: in-network, inpatient, in-network, out of so see, I couldn't do it. Inpatient, in-network, inpatient, out of network, outpatient, in-network, outpatient, out of network, and emergency and prescription drugs. So basically under this rule, if you have a plan that has a $50 copay to see an in-network psychiatrist and a $25 copay to see an in-network primary care physician, the higher copay for the psychiatrist would most likely violate the mental health parity rules because those providers are in the same classification of outpatient in-network. We had final regulations under that 2000 Act that were issued in November of 2013. And these regulations, for the first time, mentioned the concept of non-quantitative treatment limitations, or you may see that referred to as NQTLs. And frankly, this is where all of the action is today with respect to enforcement. Non-quantitative treatment limitations are those behind the scenes administrative processes that can significantly impact benefits. For instance, they would include things like prior authorization requirements, adequacy and structuring of networks, formulary design, reimbursement rates. So those things that go on behind the scene that your ASO provider, your PBM does, that impact benefits. The 2013 regulation said that a plan can't impose any non-quantitative treatment limitation with respect to mental health benefits in any classification unless it is comparable to and applied no more stringently than the limitation with respect to medical and surgical benefits in that classification. So then moving ahead, in December of 2020, we got the Consolidated Appropriations Act, or the CAA, and it requires that plans perform and document a comparative analysis of how these non-quantitative treatment limitations impact mental health benefits as compared to how they impact medical and surgical benefits. The CAA also required that plans make that comparative analysis available to the agencies that are responsible for enforcement here, the IRS, the DOL, and HHS. And they were also directed to report to Congress annually with respect to their enforcement efforts. And finally, and what has brought us all here today, as Kate mentioned, are the final regulations that were issued under the CAA just in September of last year. These regulations expanded the comparative analysis requirements dramatically and also imposed for the first time a fiduciary certification requirement, which we'll talk about in a little bit. But it's important to know that these new regulations, almost all of the new regulations, were effective 1/1/2025. So as we sit here today, these new rules are already in effect.
Thanks, Kathy. And who is subject to the law? Who does this apply to?
Yeah, the law is applicable to basically all group health plans and health insurers that offer mental health or that cover mental health benefits. The law doesn't say a plan has to provide mental health benefits, but if it does, then they have to be provided in parity with medical and surgical benefits. There are a few exemptions. I'll name a couple. Small self-insured employers are generally exempt from this, and for this purpose, a small employer is an employer who employed fewer than 50 employees for the prior year. I will note that small, fully insured plans are subject to the rule, though, so they do not have that same exemption. Standalone retiree health plans are exempt from this rule. And then there's a cost exemption that basically says if the cost of complying with the new law is more than 2% of the total plan costs, then the employer has an exemption for the next plan year. So it's a plan by plan exemption. Excuse me, it's a year by year exemption. And the employer does have to retain an actuary to justify the cost projections. And they also have to notify the participants if they're actually taking advantage of that exemption. So just a few exemptions there, but most group health plans and health insurers are subject to this law.
Okay, perfect. And then in terms of penalties for non-compliance, what are we looking at there?
Well, that can be kind of a range of things. As we know, the DOL is auditing plans right now, and in doing so, they're kind of starting to focus more on group health plans. If an employer, has a compliance issue in an audit, the employer will probably be required to enter into a settlement agreement of some type with the DOL. That'll include changes in processes going forward. It'll also include likely payment of benefits, perhaps retroactively, for benefits that the employer wasn't expecting to cover, all of which could be expensive. Additionally, if the employer has a compliance problem, they are required to notify their participants that they're out of compliance, which obviously could trigger some participant lawsuits. Another thing I'll note is in those 2024 regulations, they did make clear that the comparative analysis that the employers are required to do is a plan document that participants have a right to request. And under ERISA, if an employer fails to provide that within 30 days, the employer can be subject to penalties of up to $110 per day. Go ahead, John.
Kathy, just for a moment, there's a couple things in here. One is the comparative analysis that is a pre-step that sounds like everybody should be completing or have access to. The second and kind of related item that popped out at me with regard to 2025 is this idea of fiduciary duty in vendor selection,
Right.
And having, a quote unquote qualified service provider.
Yep.
Could you talk a little bit more about the comparative analysis, the production of that kind of report, and how it relates to evaluating your service providers?
Yeah, and I think maybe I'll toss that over to Marty.
Well, clearly, the final regulations did, for the first time, make it an affirmative fiduciary duty to engage a qualified consultant to do the comparative analysis. It is a full-fledged fiduciary obligation. The regulations are also very specific. I want to talk about this more later, John, that fiduciaries have to certify that they engage in a prudent process to engage the consultant to do the analysis. They have to also certify basically that they monitored the consultant and the performance of that report. All those things need to be documented. But what's really interesting hearing the discussion that you and Kathy are having, and I'll just kind of ad lib here, is this concept of liability. Because Kathy, you mentioned that if you fail to comply with the requirements of the law, that one aspect is plans can go back and be ordered to pay benefits retroactively for prior claims. You also made a subtle reference to 104B, and it's really an interesting tidbit when you go through all the regs, and the regs are incredibly complicated when it goes to the nuances and the contents of a comparative analysis. But there is one minor change, and it does say that when you operate an ERISA plan, that the comparative analysis is a plan document under which the plan is operated. That sweeps into what your comment, Kathy, about 104B, and 104B gives that per diem penalty of $110 per day at the court's discretion for not complying the comparative analysis. And so that's where, when you talk about the practical risk of this, part of it is just litigation risk. That plaintiff bar, which we can talk about in more detail, becoming more and more sophisticated in these areas. And it's just another tool for them to come after plan sponsors. Hopefully,
And the other
John, that
thing-
answered your question.
Right, Marty. I
It-
think when we talk about excuse me, John, when we talk about the request for the comparative analysis, you kind of have an issue either way. So if a participant requests that analysis and you can't provide it within 30 days because you haven't gotten it complete, you could have penalties. On the other hand, if you have done it and you give it to the participant, we can expect probably the plaintiff's lawyers are going to have their own experts, and they're going to start combing through these comparative analysis and look for problems. And all of that, I think, is going to relate or result in some more litigation by participants.
Yeah, I think that's a key for me as I think about the employers and the health plans we support. The jeopardy isn't just from the Department of Labor or other regulatory bodies. There's, real jeopardy from individual, terminated employees who, are rattling the saber and saying, hey, I know this is a weakness and I'm going to exploit it for my own personal benefit. And we know that doesn't come from the individual members. It comes from the attorneys that educate them about this quote unquote opportunity.
If you think about the new regs, big picture, the government is forcing us to disclose to participants our mistakes. And we know from the state of litigation where we're at right now that the sense is the plaintiff's bar has pretty much tapped out the retirement plan area in terms of novel ideas, big class actions. I mean, they're still being filed, but they're now looking into the health and welfare space. You can look to the PBM cases as an easy example of the start of a new trend. But now you layer on this new regulation, and there are details to it. But in essence, you have to do the analysis. If the analysis is requested by the Department of Labor and they disagree with it, then as Kathy mentioned, you have to notify participants that your analysis was non-compliant, which is just giving to the plaintiff's bar an admission that, at least from the DOL's perspective, you're not in compliance. It's a recipe for a disaster right now.
I have one additional question on timing, Kathy. What's new in 2025? Sometimes these regulations are effective as of year end. Sometimes they're effective as of January 1st. Is this a January 1st obligation?
Yeah, most of all of the new provisions including the fiduciary certification in those regulations are effective now. They were effective 1/1/2025. There are a couple of pieces in there that are not effective until 2026, but that's kind of the least of our worries. Most everything is already effective at the beginning of this year, which is not helpful either. And
And Kathy, given that timing, what are you seeing in terms of audits? Are you seeing an increase in audits already, or any activity?
We're definitely seeing audits. The DOL is required to do audits. And I would say they have turned a little from ASO providers and insurers to more group health plans now. So employers now with self-insured plans, I think, are becoming more the target of those audits. And it's, like I said, if you're in an audit, you have, it's pretty stringent requirements. You have 10 days. They will, once you get that audit request, you have 10 days to provide your comparative analysis. And, then you have 45 days to clean it up if there are anything, if there's anything that comes up. But at the end of the day, the DOL has noted that there is widespread non-compliance, which is not surprising since the rules are so complicated. And so at the end of the day, there, likely will be something that you have to clean up, and that will require some type of a settlement, probably with the DOL, and changes to, plan terms. And I will note, it's interesting that the DOL is also required to state the names of any plans that are ultimately issued a notice of non-compliance. They do that in their annual statement to Congress. So
So that's going to be
it's not a secret. It's not a secret thing. Yeah.
Yeah, interesting. So you talked about the challenges in terms of the timing for one, but just in general, I'd open it up to all of you. Can you talk to me a bit about what is so challenging about complying with these regulations? What are the actual pain points that employers are facing already today?
Yeah, I think so part of the rules, we're looking, as I said earlier, we're looking at treatment limitations and financial restrictions. Those things I think are pretty straightforward. And the DOL actually has issued a self-compliance tool to help employers with that piece of the regulation. And for the most part, an employer, and certainly their consultant could work them through that. The problem is this non-quantitative treatment limitation piece of the regulations. It is huge. It is extremely complicated with respect to this comparative analysis that you have to do and the data that you have to obtain and crunch to get there. And part of the problem is that the employer does not have this information itself. This is the processes of the ASO provider and the PBM provider. And so they have all the data because they're the one that does all of that. So part of it is just getting that data. If you can't get your ASO or your PBM provider to agree to actually prepare that comparative analysis for you, then part of the problem is just to obtain all of that data and then make sure you have a provider who can crunch that and put it into a comparative analysis that's compliant with the Act. And I don't know, John or Marty, if you have any thoughts on that.
Well, one of the things that, leaving the complexity of the analysis aside for a second, one of the things that popped out at us as we were educating ourselves is this 10-day turnaround time. And I think about how hard it is to get data, basic data out of a TPA or PBM. Now I'm working with extra data in a shorter time frame. To me, if somebody hasn't taken the pre-steps, they're kind of done in one, because I'd venture a statement to say 80 to 90% of TPAs or PBMs are not going to be able to deliver new data in a 10-day window.
That makes sense. And then in terms of contractual terms, are you seeing that contract terms with the ASOs or the PBMs require the data to be provided, or do you have any advice on how to get those changes made?
It's interesting. This is an issue that we talk with our employers about. There's very little specificity with regard to data delivery requirements in TPA, ASO, or PBM contracts. There is an ongoing arm wrestle with the sources of those data as they try to restrict, its flow, the information flowing outward. So under normal terms, getting data is incredibly hard. CAA has been a huge step up to give employers some real teeth to request the data. Candidly, I have not seen any terms in ASO agreements or TPAs that speak directly to these comparative analysis. So I'm curious, large to small, what people are actually doing about it in the contracts.
Yeah, and I think we're sort of developing best practices right now as we go through this. Now, obviously, when we look at contracts, our preference would be that they say that the ASO or the PBM will prepare the analysis for the employer, which kind it makes sense. It's not unfair because they have all of that data. They're the ones who are, applying it to mental health benefits versus medical and surgical. If we can't get that, then short of that, John noted, I mean, you have to have a provision that the ASO or the PBM will provide, any reasonable data that your consultant requests so that the consultant can prepare your comparative analysis. And then beyond that, we have thought about perhaps other contractual provisions we could get in there that would be helpful to an employer. For instance, a provision that the ASO will notify the employer if there are any major changes that might impact the comparative analysis, such as, a major change in the mental health provider network. For instance, but so yeah, I mean, we do, as we're doing these agreements, it's vital that you address that in there. And if you have an agreement out there right now and you're not in a situation where you're renewing, you still really need to go talk to your provider about what they can do for you and what they'll agree, and you need to work through those details.
The other thing that strikes me, Kathy, is even if the TPAs or ASOs are obligated to either provide the data or do the comparative analysis on your behalf, you stated earlier that a high percentage of organizations are not compliant and need to take action on those findings in the report. What strikes me is I'm not seeing these reports flow around and people review them to check for remediation. So that gap is curious for me.
Yeah, I actually recently saw a report that saw some reports that from a PBM and an ASO provider, and it was very long and very detailed. But when you look at it, you can pretty quickly see, well, why didn't they cover this, or where is this part of it when you try to compare it to the regulation. So I do think even if you get your ASO provider, your PBM provider to do that comparative analysis for you, I think you still have to have your consultant to review that. And I don't know, Marty, what your thoughts are on that. I think
I agree,
you can't
Kathy.
just take it wholesale because of that fiduciary obligation.
100% agree. I'm glad that you threw it that way because, lots of times the ASOs, especially where you have networks, you could view it almost them having a conflict of interest in the preparation of that report to maybe take the position something is compliant. So I wouldn't blindly rely on a report from a PBM or an ASO, because again, the fiduciary has to basically sign off on these reports. And I think prudence dictates at the minimum that you hire a qualified consultant to review that report and check for conflicts of interest, content, etc. So I agree with you, Kathy.
So we actually have a few questions in the Q&A. So are you all ready to answer? Let's do it. Okay, so the first one is about that fiduciary certification, Marty, and I think you said you were going to share more. Their specific question is, I'm not sure who the fiduciary of the plan is, who signs that certification.
Yeah, so the short answer, Kate, to the extent I ever give a short answer, is that your health and welfare plan needs to name a named fiduciary. That's a requirement of ERISA. And so I think the first step for employers is to identify who the fiduciary is of that health and welfare plan, either by affirmative designation in the plan document or by some type of formal delegation by the plan sponsor. But that formal fiduciary is all of these obligations we're talking about on the analysis. It falls on that individual or committee.
And who usually is a fiduciary for a health and welfare plan, Marty? I'm putting you on the spot.
You are. It varies, Kathy, as you know, in the old days when we started practicing together 30 years ago, committees were pretty common. And now what we've been doing, unlike for retirement, where committees are still somewhat good for investment purposes, for health and welfare plan administration, it's usually an individual these days, whether the head of HR, head of benefits, somebody like that. So it's usually a named individual versus a committee. But it can be either. It depends on the employer.
Okay, the next question is a different angle. Are EAPs subject to mental health parity regulation? So EAPs being employee assistance programs that now frequently have some mental health built into them through often it could be any type of provider, but they'll have a limited number of benefits.
Yeah, that's a great question, because you would think that an EAP, because it has that mental health component, would be subject, but generally they're not. And I say if it's a typical EAP where it doesn't provide significant medical benefits, it's not coordinated or part of the with the medical plan, and there's not a premium paid by the employee, and there's no cost sharing. Generally, that type of a typical EAP is exempt from these requirements. And I'll toss in also that a typical health flexible spending account is generally also not subject to these rules, in case that question comes up.
Okay. Super helpful. And then somebody asked, have we seen any recent legal actions or penalties against employers who are not in compliance so far?
Well, we're clearly seeing audits by the DOL. There have been cases against employers. There's been a case certainly where an employer was subject to penalties for not providing certain information regarding a mental health claim. So there have been some cases out there. Given the spike in healthcare litigation recently, though, as Marty noted, I think we're going to start seeing a lot more participant claims that are going to be driven by the plaintiff's bar.
Makes sense. And so I think this one might be for you, Marty. What are some of the biggest misconceptions employers have today about their responsibilities under mental health parity?
I would say the basic misconception is that they feel like they don't have responsibilities. I mean, they are aware of mental health parity, it exists. But I think the misconception is that by having qualified PBMs, ASOs, brokers, consultants, however the third parties they engage to manage their plans, they assume all of that is being undertaken. And the reality is, especially now, that's not true. It is a fiduciary obligation.
All right. And actually, the next question is kind of a different side of the coin, which is, I thought we were already required to do comparative analysis. What's changed? Why the urgency now? And then they followed up with, we actually didn't do it. We delayed it. So do we have exposure for prior years?
You were required to, technically, you were required to do an analysis, I believe, beginning in 2021. The reality is that most employers did not do so. How it came up, though, was through DOL audits. So if you actually were one of the employers audited, they would discover you didn't have the analysis, and employers would scramble to do the analysis. What's changed is the final regs. The final regs, again, layer on the two obligations: fiduciary duty obligations and all its attendant consequences and risk, and also the 104B comment that Kathy and I both have spoken about, that it is part of the plan document, opening the door to additional penalties, and again, being attractive to the plaintiff's bar. Do you have a risk for prior years? I think in theory that risk does exist, but if I'm an employer, I would give all my attention on 2025 right now, and to the extent through this engagement process, to the extent nothing has changed, for example, from 2023 to 2024, maybe your consultant can kind of overlap and kind of give some type of analysis for 2024, 25, multiple years.
Yeah.
But the risk is there, but I think the risk for 2025 is so obvious. That's the attractive risk to the government and the plaintiff's bar.
Marty or
Hopefully that
Kathy,
answers it.
as I listened to this, one of the things when you talked about the conflict of interest with the, let's say the TPA, who represents a network, and there's always are they serving the network? Or are they serving their plan sponsors? An issue that we hear consistently with employers is that mental health access is an issue, which means network quality is not at parity between, let's say, access to a surgeon versus access to, psychology or psychiatry. How does that play into this? Is that in the report somewhere? Are people hiding the fact that these networks aren't at parity, independent of a single employer plan?
Kathy, you want to take that or you want me to?
Go ahead. Definitely that is a non-quantitative treatment limitation that has to be analyzed and has to be part of that report. Now, how that's characterized, if you know you have a problem, I guess, I guess it depends on whether the problem is, I don't know, lack of trying, whether you just haven't tried to structure, a comparable network of mental health providers. That's one thing versus, they're just not available. That would be a different concept. And I don't know, Marty, what your thoughts are.
Well, I think the reality is that but for these requirements that the analysis be undertaken, it is nearly impossible for a purchaser, an employer, to know whether or not the network is adequate. I mean, the analysis does provide value, no matter how much we don't like it. It does provide value. Otherwise, you're really blindly relying on the ASO. And it's not just on mental health. You could go beyond that on other issues, Kathy, that you and I have wrestled with. It's a hard industry to stay on top of.
Mhm.
The
And
other
just sharing, oh, go ahead, John.
area of exposure, sorry, Kathy, we have a lot of small and mid-sized employers that we serve. And one of the strategies is to avoid the major networks, put a network in place and do something like a center of excellence, which cares for, let's say, surgical need. By definition, these networks are narrow and don't have parity on access. Is that kind of a systematic problem?
Marty, do you have any thoughts?
Well, from my experience, when you have a plan that has, let's call it the centers of excellence approach, John, typically they provide value to a small segment of the overall plan population, those in need of hip replacement surgery, whatever it is. And so when you're doing the analysis, usually the COEs are not an important part of the analysis because of the numbers and dollars going to it. It's really the core medical and surgery benefits that the mental health is being compared to. And I didn't quite answer your question, John.
No, I think implicitly you did, because if we have a high performing surgical network because we've augmented our plan, we've in essence raised the bar on that care and haven't raised the bar on mental health care.
I do agree with you, John, that as that type of design takes off, and it's not really new to the area, but is clearly a growing trend, right? Right now it's accelerating to have what I'll call inappropriately the COE approach. As that model gains traction with participants, it does have the possibility of really affecting the analysis and driving up an obligation for mental health. Because my assumption assumes, for example, and Kathy, I forget the numerical test in the regs, that fewer than 10% of surgery medical costs are flowing to the COEs. But as that goes up, you're right, it does affect mental health. No doubt about it.
Yeah, and I can't pretend to know the outcome of that analysis, but we are seeing mental health COE models as well, particularly for substance use disorder and other conditions that require longer term treatment. So maybe that will help balance it if a plan had both offerings simultaneously, but of course, hard to say without seeing the actual data. One more question before we kind of hop back. Well, two, I want to share the benefit of a couple of comments that were in the chat. One person noted that as you recommended, having doing an independent review of a report that an ASO creates for you, it's going to be extraordinarily hard to do that without the data. So there would remain some challenges in that, particularly for places that don't have expertise in-house. And then just a data point to share, another participant shared, smaller employers are struggling with the cost of NQTL. I've seen fees upwards of $12,000 to perform the analysis. It seems like a large barrier to compliance for small groups, which I think is acknowledged by, one of the exceptions, Kathy, that you mentioned, but of course that there's also a cost to getting the actuarial analyses done. So none of it is easy, certainly for smaller plans. The final question here is, can the fee to perform the analysis be paid with plan assets?
And the answer to that is yes.
Great.
If you
Perfect.
have plan assets.
Yeah, if you have plan assets.
Okay. That's a good qualifying statement. Okay, so I'm just going to share a slide again, a new slide. Can you take us through, this slide is meant to address the question, if employers kind of take away nothing else, what should they take away practically as next steps?
All right, so I guess, Kate, I'll try to answer that question. John, Kathy, feel free to supplement. So yeah, that is the key piece of this, is that clearly we know that the comparative analysis is now a fiduciary obligation to be undertaken. Question is, who does it? And let me start very clearly. It is not the employer, okay? And there are reasons for that, even if it's the fiduciary of the plan, it is not qualified in nearly all cases to actually conduct the analysis. And even if they did conduct the analysis, I think it does present conflicts of interest, perhaps. So it wouldn't be the employer who actually does the comparative analysis. Secondly, and most importantly, Kathy, you'll love this, your benefits lawyer, do not expect them to do the comparative analysis. They can help you in the prudent person process, but they are typically, unless they're in-house at a consulting firm, they're not going to have the expertise and the technology available to do these types of analysis. What that leads to then is you're looking at a consulting firm or an actuarial firm, firms of that nature, to actually do the comparative analysis on behalf of the fiduciary. We talked about fiduciary. Again, the first question for any employer is to identify the fiduciary of the plan. And just as a heads up, if there's any confusion and the employer, for example, Kate, if Denton said, Kate, you are fiduciary, go ahead, hire the outside consultant. It doesn't matter what our plan document says. If you're the one who exercises the fiduciary authority to engage that consultant, for all purposes of ERISA, you are the fiduciary for that piece of the plan's operation. So identify the fiduciary. Then the question is, what is the process? The regulations really track basic fiduciary law. If you're familiar with fiduciary operations of retirement plans or other aspects of health and welfare plans, what's required is that the fiduciary engage in a prudent process to engage a competent consultant to undertake the analysis. Fees, obviously, are one piece of that component, but you never sacrifice quality for fees under the prudent person rule under ERISA. Secondly, when you are engaging a qualified consultant to do the analysis, you always have to take a step back, like you would any other engagement, and really ask, is this consultant qualified to undertake the analysis? Don't necessarily grab for the first consultant that you've been introduced to. Check into their credentials, their experience. For example, most fiduciaries, when you hire someone to do fiduciary work like this, they will interview 2 or 3 entities to actually, before they engage that consultant. All steps undertaken by the consultant, again, because it's a fiduciary obligation, it has to be done prudently and documented. And the reason why the documentation is key is because in the event there's any litigation down the road as to whether or not you prudently engage the consultant, you won't have any records of it if you don't maintain it, right, and document it. And that's your biggest defensive piece of evidence for you, is the documentation of how you undertook the search for the qualified consultant, how you made your decision, how you made sure that this entity was qualified to do it. Once you engage the consultant, then, right, you, the committee or the fiduciary, maybe outside benefits counsel, will work with the consultant, your ASO, your PBM, other vendors who have the data, right? But for the data sharing, this is where John comes in, but for the data sharing and analysis, it is impossible to get a qualified report. But once you get that analysis, then the fiduciary obligations don't stop with that. Once that report is tendered to the named fiduciary, again, the final regulations make it clear that the committee has to, or fiduciary, has to review that report and basically prudently accept the validity of the report. Under the final regulations, a fiduciary is not required to certify that the report is accurate. All they're required to certify, again, this is a formal certification, that they have reviewed the report and they have prudently understood and considered that report and are comfortable with that report. But again, part of that analysis is when you engage, make sure that your RFP, if you use the RFP process, make sure that that report is exhaustive and contains all the elements required by the final regulations. Otherwise, it's not meaningful, right? And then lastly, I guess, I do want, I mean, that's really the process, the fiduciary process that you go through. But I wanted to close that piece of it, though, is the significance of that process. As Kathy and John alluded to, that report has to be provided upon request to the government. The government will review that report. They will give their own opinion as to whether or not that report is complete and satisfactory. If they have objections, they will contact the fiduciary. You will contact the consultant, and you have 10 days to correct or complete that report. But keep in mind, again, at the end of this process is the new leverage the government has given the plaintiff's bar and participants. If that report is, if you cannot come to agreement with the government, then you have to notify all participants under the plan within 7 days of that final determination that you have a non-compliant analysis. And at that point, again, all it takes is one plaintiff lawyer to contact one participant in the plan, and plaintiff's bar, again, very sophisticated. We have clients where you can go on the internet and they say, do you work at company XYZ? If so, give us a call because your retirement plan's out of compliance. They're searching for class action representatives, but that's all it takes. And again, once you get in that cycle, you have fiduciary risk, personal liability for damages. You have the opportunity for retroactive claim adjustments, the 104B request for documents, and then you always have attorney's fees. And I think Kathy or John, you alluded to the Montana case involving the award of, I think, $32,000 in 104B penalties. Keep in mind, in that case, the court ruled in favor of the employer on the substance of the claim. The court ruled that that mental health claim was properly denied by the ASO. But despite that fact, the court said you didn't provide these documents. Again, the analysis is part of that now. And therefore, we're awarding you $32,000 in penalties. And also remember under ERISA that even if a plaintiff loses in court, if a court believes the claim had merit for judicial consideration, it will still award plaintiff's attorney's fees and make the employer pay plaintiff's attorney's fees. So that's the big picture, Kate, that we're playing with. Kathy, John, did I miss anything from that perspective?
No, I think it's a very good summary, Martin. You know, what I'm hearing is if you haven't taken the steps to walk through the process, you're really leaving yourself exposed. And then the piece under that is, how do I find a qualified provider? And the piece under that is, you know, do I have access or contractual rights to data to support the analysis being done by that provider? So, you know, the key here is if you haven't started, you probably should.
And the industry is catching up to the regs. I have, over the last month or so, asked some of our larger clients where they stand on this. Has it been discussed by consultants? They're a regular consultant. And so far, clients have not really initiated the process. I did speak to one earlier Monday of this week, and they did say that their consultant finally they meet monthly and it's on the agenda. So consultants are gearing up, I think, to start this whole process, hopefully in a fairly cost-efficient manner, but that's yet to be seen.
Yeah, I would share for the audience that I have only heard our largest clients speak of this issue, and probably 80% of our portfolio has been silent on the topic, or we haven't been involved, which is entirely possible.
And John, where would Wellnecity come into play here? Would that be with respect to data access or other elements?
Yeah, we, as a data hub, working on behalf of the plan to support their decision-making and management or compliance with regs and or management of vendors, would step in and explore alongside of them what is in their contract with regard to data access. And then as we get into deeper detail, do we have the actual information that we need to support an analysis? So that would be our role. And it's something that's in our wheelhouse and part of our base service, as long as we get the question.
Perfect. And then just a question for all of you. What's on the horizon that that our audience today should keep in mind as we look forward to what might happen here?
Well, I can jump in there. On the enforcement side, it's unclear at this point whether the new administration, whether there will be a policy shift on this. It could be that there could be some budget and labor constraints, that may impact audits being done and the number of audits being done, but we'll kind of have to watch that. We're fairly early on that. We'll also be watching the lawsuits with respect to the regulations themselves. In January, the ERISA Industry Committee, or ERIC, filed a federal lawsuit in the DC District Court, alleging that the agencies overstepped their authority when they issued these regulations, and they're seeking to invalidate the regulations entirely. So we could see perhaps a nationwide injunction for some period. It is possible that those regulations are vulnerable in light of the Supreme Court having struck down last year the Chevron standard. That was the standard that generally gave deference to an agency's interpretation of a statute. So with that gone, it makes it easier to challenge regulations. So we'll have to watch what happens to those regulations. But I do want to stress that whatever happens in that case, the mental health parity rules are out there in, setting aside the regulations in substantially the same form, and they're not going anywhere. So, whatever happens with respect to that case, you must proceed with your compliance efforts. Absolutely. And I guess we'll also be tracking participant litigation. Like we keep saying, when the plaintiff's bar gets a hold of this, we can expect, I think, that this is fertile ground for more litigation. So we'll just have to see where that goes.
Perfect. Okay, well, I want to just wrap there, Kathy. I think that provided a really nice wrap that this is real. There are steps that employers need to take for their plans. That's not something they can do on their own, and it's not just a regulatory enforcement action that they need to keep in mind, but also protection against potential litigation. So I want to let everybody know we do have slides. We just thought you'd prefer to see our faces. So we'll send out the slides with the content so that you can share that with your teams, follow up with any questions that you have. The slides will also have our contact information, which is shown here. So you can feel free to reach out to any of us with questions that you may have as you go through. And I want to thank Kathy and Marty for the great content that they brought today, but very much thank John and Wellnecity for having us and hosting it. It's so important, I think, to take advantage of these opportunities to learn together, particularly when things are really complex. And we appreciate the opportunity to be part of that with Wellnecity today. Thank you.
Okay,
All
thank you.
right.
I would similarly like to add some thanks here. First, to the advisors out there that first surfaced this issue. And as we polled across our portfolio, we recognized that it was a common need. So those ideas are important to bring forth, and we hope we were able to kind of meet a need today. And then second, I really want to thank the Dentons team for the time and quality of expertise that they've brought to facilitate this conversation and raise the bar on knowledge for our group. So thank you.
Thank you.
Thanks. Take care, everybody. Bye-bye.
Bye-bye, guys.
Care.